Hey everybody, John Skiba here from the Consumer Warrior YouTube channel, and in today's video we're going to talk about bankruptcy in the year 2025. 2025 sounds like we're living in the future. But if you are dealing with serious debt issues and you're saying, you know what, this is it, 2025 is the year we're going to get out of debt, be able to move forward, then this is the video for you. But if this is your first time here to my YouTube channel, please go ahead and click subscribe, check on that little bell. That way you'll be notified each and every day when we put out new videos that'll help you deal with serious debt issues. So I'm recording this video in November 2024. We're getting ready, we're at the end of the year, getting ready for that new year in 2025. And if you're dealing with serious debt issues that just don't ever seem to be going away, you just can't get a handle on it, I want to talk today about the Chapter 7 bankruptcy process, how it can help you as you move into the new year and getting these debt issues dealt with once and for all. Now, most people, when they think of bankruptcy, they're actually thinking of the Chapter 7 process. Chapter 7 is a relatively simple process in most cases. It's also pretty short. It's about a 4 to 5 month process. I know you're thinking that sounds really long. Trust me, for a federal court proceeding, which is what bankruptcy is, 4 to 5 months is smoking fast. So there are different steps. I want to walk you through each of those steps today as we talk about the Chapter 7 process, what to expect, some of the pitfalls that you got to be concerned about. And then if you are in Arizona, that's where I practice law. I do a free consultation where I can discuss specific questions that you have. If you have other questions, go ahead and put them in the comments below and I'm happy to see what I can do. But by numbers below, I do a free consult. You'll talk directly with me and we can figure out what the best option is for you. Now let's talk about before your case is filed, because that's really, when we look at Chapter 7, it's really kind of what we call pre-petition, pre-filing, as far as what happens there, and then post-petition, what happens after the voluntary petition is filed with the court. Now pre-petition, it's a lot of information, a lot of documents. I tell all clients when they work with me here in Arizona that, hey, this is going to be a little bit tedious. The typical Chapter 7 bankruptcy is about a 100-page document. So we work with you to gather information on income, on monthly expenses. We have to get a list of all your creditors. Usually we can download that information from your credit report, where we can get balances, account numbers. But a lot of times there's debts that don't show up on credit reports, like medical bills, or maybe you have like a personal loan that's not going to show up there. So we need to get that information from you so that we can accurately draft the bankruptcy petition and schedules, which are the documents that we're submitting to the court. Not only that, but a lot of different transactions. We have to report income over the last couple of years, if you sold anything, if you transferred anything out of your name. And this is a good point to say, if you're considering filing bankruptcy, particularly Chapter 7 bankruptcy in the near future, talk to an attorney like myself before you do anything. Don't sell anything, don't transfer anything, don't buy anything. Some of those transactions, when they happen just prior to filing bankruptcy, can cause you some pretty big issues. So it's best to keep things kind of just status quo, keep things as they are right now. And then once you talk to an attorney, you can kind of put a plan together that makes sense so that you can get the biggest impact and benefit from the Chapter 7 filing and avoid a lot of the problems that sometimes people have when they file a Chapter 7 bankruptcy. Now, before your bankruptcy case is filed, not only are you going to have to work with your attorney to provide all of the documentation, all the information, but you're going to have to take an online credit counseling class. Now, this is no big deal. It sounds a bigger deal than it is. It's actually about a 1-hour online video class that you have to take and have a certificate that you'll get saying that you took it. It's not a big deal, but it has to be done. The attorney cannot file your case until you complete the online credit counseling course. So you got to get that taken care of. Once all the information has been provided, the schedules have been reviewed and drafted, and you've gone through them, making sure that the information is correct, which is vitally important. Part of the bankruptcy process is that, a lot of people sometimes will tell me, well, how are they going to know if I have certain assets or don't? The way that they do that is they require you to disclose those assets, and then they put a huge penalty if you fail to disclose them, particularly if you intentionally fail to disclose them. Intentionally failing to disclose an asset in a Chapter 7 bankruptcy is a felony. People do go to jail for it, so you got to be careful of this and making sure that you're doing your best to disclose assets. Now, if you inadvertently forget something, not a big deal. You can let your attorney know and we can amend the documents going forward. Now, once we have all the documentation prepared, you've done your credit counseling class, we can then file the case with the court, and one of the most powerful tools in the bankruptcy toolbox comes into play. That's called the automatic stay. The automatic stay is a provision of the bankruptcy code that states as soon as that case is filed, automatically an order comes into place that stops all collections. Creditors can no longer call you on the phone. They can't email you. They can't send you those nasty grams. They can't do anything that could be interpreted as trying to collect money from you. This also applies to they can't repossess vehicles or foreclose on your home. So all collections stop. And really, this is that kind of the breathing room and the fresh start. This is where it begins, because if you're dealing with something like a wage garnishment, if they're trying to take your car, all that stops the moment we file it. Not only that, we can even file what we call emergency bankruptcy filings, where they allow us just to file what's called the initial petition, which is just a 4 or 5 page document with your name, address, social security number. We can file that with the court, and that will invoke the automatic stay and stop those collections. Sometimes we do that when people come to my office here in Arizona and they have like a home that's being foreclosed on the next day, or vehicle repossessed, wage garnishment. We can stop those almost immediately and get that filed even sometimes same day to stop that collection. So once we get everything submitted to the court, the automatic stay is in place, then you're going to get noticed of what's called the 341 meeting, or the meeting of the creditors. 341 just refers to the bankruptcy code section that is provides for this meeting to happen. And what it is, it's done via Zoom. This is a big change if you have gone through the bankruptcy process before. It used to be we had to go down to the courthouse. Now, this hearing is done via Zoom. It's a Zoom video conference with you, your attorney, and a bankruptcy trustee. Now, the bankruptcy trustee is not the judge in your case, but the bankruptcy trustee's job is to, one, conduct this meeting, to ask you some questions, to put you under oath and ask you if what you've submitted to the court is accurate. The trustee will also look to see if there's any assets that you have that could be sold with the proceeds going to benefit your creditors. Now, that's kind of the big picture view of a Chapter 7. It gets rid of all of this unsecured debt, credit cards, personal loans, medical bills. Those debts go away completely. However, the bankruptcy trustee is going to see, are there any assets that you have that can be sold for the benefit of your creditors? Now, the good thing is most things are protected by exemption laws. Now, every state has their own set of exemptions. These exemptions, a lot of people have heard of like the homestead exemption that protects equity in your home. There's exemptions for vehicles, household goods, retirement accounts. In Arizona, there's exemptions for musical instruments, firearms, pets, all these different kinds of things. So this is one of those things, if you're worried that you're going to lose everything through the bankruptcy process, I can tell you in over 90% of cases, people don't. They typically don't lose anything. And so it's something where that's where it's good just to have that consultation to go over what assets you do have and put a plan in place to make sure that you can keep those, or at least that you're aware that they could be at risk if you were to file Chapter 7. Now, the Chapter 7 341 meeting, like I said, it's called the meeting of creditors. It's a little bit misleading as far as the title, because very rarely do creditors appear. In fact, I've been doing this almost 22 years. I've only had creditors appear in a handful of cases, and I do these hearings almost every day. And so it's very rare. If there's a creditor that wants more information, there's a mechanism for it to do that. They do usually 4 to 6 of these meetings every 30 minutes. So there's not a lot of time if the creditor has very many questions. So once the meeting of creditors is done, and like I said, very brief meeting, they put you under oath, ask you if what you've submitted to the court is accurate. In Arizona, they ask you if you've lived in the state of Arizona for at least 2 years, or if you filed any prior bankruptcies in the last 8 years. Those are the types of questions you're going to get. Here at my office, we get our clients totally prepared for the meeting, and it's not a big deal. After the meeting of creditors is over, you're going to have to take a second online credit counseling course. It's a financial management course. It takes about an hour and a half. It's just done online. You'll get a certificate that says it's completed, that's submitted to the court, and then you're done with that. And then it's really just a matter of waiting for the bankruptcy trustee to complete their part to get the case ready for discharge. The discharge order is the order from the judge in your case that says your case is done, that those debts are no longer legally obligations of yours. They've been eliminated, they've been discharged, and the case is essentially over. However, once the discharge is entered, the clerk of the court will not administratively close out your case until the trustee has done everything you need to do, everything's done on the clerk's side, and then they will administratively close out the case so that there's nothing else that needs to be done at that point. So that's just kind of big picture view of what you can expect from a Chapter 7 process. Like I said, the key to having it go smoothly is really disclosing fully all of your information to your bankruptcy trustee. The last thing a bankruptcy attorney wants to do is be surprised by either a certain debt or asset that they didn't know about ahead of time. So if you can do your best to fully disclose that, the process in most Chapter 7s is very, very smooth, gets you a lot of debt relief, and allows you to move on pretty quickly. Again, if you're in the state of Arizona, check out my information below. I do free consultations. You'll talk with me directly, and I can help put a plan in place for you to be able to get the debt in the rearview mirror once and for all. Thanks for watching today.